Ladies and gentlemen, I have been asked to discuss with you in the next 20 minutes, and that's going to be a challenge. In the next 20 minutes, I have to discuss with you final account disputes, going beyond record keeping. Sorry, Max, because Max always says that records, so we have to go beyond record keeping, how to gain an edge in this area. And what are the risks and the obligations of the expert witness? So quite a lot here to go through, but I'll do my best. And as they say, you don't eat the elephant in one go, but you go bit by bit. Final account disputes. What are they? They are really cost overrun disputes, where the cost, the end construction contract price, is higher than the contract price you originally signed for. The difference in between is the overrun. Due to the complex nature of construction process and the complex nature of inter-parties, because there's many parties on a construction project, relationship and dealing with it, you can safely say that overrun is a regular feature on construction projects. An Australian judge once qualified construction projects as being very close to a battlefield, and he was right. He described and said as follows: except in the middle of a battlefield, nowhere must men coordinate the movement of other men or material in the midst of such a chaos and with limited certainty of present facts and future occurrences, as in a huge construction project. And he goes further. He says even the most painstaking planning frequently turns out to be a mere conjecture, and the accommodation to changes must necessarily be of the rough, quick and ad hoc sort, analogous to every changing commands on the battlefield. That's what we're talking about, a battlefield and all those moving parts. The one thing you have to do, and that everybody is in agreement with, the one thing we have to do is to get the back-end lawyers out of the equation. Do not bring the litigators into this. We have to avoid that. It's expensive and you never have any winners. We're in agreement on that. I've been asked to give you the edge. How can you have an edge if you're the client on a construction project? What you have to bring in, and the very first person actually that you should bring in, is the front-end lawyer, the construction project lawyer you bring in. His role, her role, not well understood. But I would say to you that that person is not a litigator, but is actually an advisor. He will advise the client how to make sure that the project runs smoothly. He's an editor. How many scope of services, scope of works are so badly written that you wonder if it was written in English? The front-end lawyer can go through this. He's not qualified to tell you what the scope of services are, but he can actually assess whether the message is clear. He's also the communicator. He's going to make sure that everybody knows what they have to do. And if there is a dispute, he'll be, or she will be able to say, sorry, but this was your scope. Very important is he's going to, or she's going to draft the contract. Now people say, oh, it's very easy. It's just a standard form. Pick the one. The architect can do it. The QS can do it. The project manager can do it. Just pick one and we go forward. That's the first mistake. The very first mistake, because you need to know which form of contract you're going to use for this specific project. And then you have to amend it. You have made special clauses that will be applicable for your projects. Okay? That is what a construction lawyer can do. You also have to have someone that can think in a system. We're not talking one contract. We're not talking 5 contracts. At a minimum, we're talking 20-25 contracts, and they all have to work together. You're going to say 20-25? Absolutely. Architect has to be appointed. Engineer. Now we have an electrical, a mechanical and electrical or a civil engineer, but let's say we're an engineer. Then you have the project manager. Then you have the assigned certifier. Then you have the health and safety project supervisor design process, and I can continue, and I'm only at the design stage. After that, you have the insurances. You have the bondsman, who will have a bonds contract. You have the supply, the management contract, the domestic or nominated subcontractors, the manufacturing contract. I only name a few, but they all have to work together. If they don't work in a system, it's not working. So a standard form of contract is not going to help you for all those details. He can help you, she can help you. Records, Max Abrahamson always said records, records, records. That's fine. But where are those records? Where will we have those records? Who keeps them? Your design team. That's fine. But what if you need to sue the design team? And most of the time there's a dispute, which is workmanship or design. So where are you going to get those records? I would advocate that your front-end lawyer should have all that information so that if a dispute occurs, he or she has that information at hand. And of course, that costs money, but it doesn't cost what a litigator costs. Now, let's have a look at one contract. One contract. What is a contract? Is it the terms and conditions? No. No. It's the terms and conditions, it's the scope of work, and it is the price, and they all have to go hand in hand. It really is the holy trinity in construction work. If it doesn't work together, it is chaos, as the judge said. So, the lawyer will look at the terms and conditions, but most lawyers don't look at the scope. Wrong. The front-end construction lawyer should look at the scope. Most lawyers would not look at the price. Wrong. The front-end construction lawyer will look at the price and make sure we're using at least the same terminology. What is the final account? We're talking about final account. Well, the final account is really the situation whereby we have finality. We close off and we agree what eventually has to be paid to the client, to the contractor by the client. That is what a final account is. The legal terminology in most of the contract is that you have to have applied the necessary effects of all those terms and conditions. Remember, one part of the Holy Trinity, that all those terms and conditions have been applied in the adjustment of the contract price. What are they? Variations. You might have asked for extra work or change of methodology. How do you deal with variations? Well, you have to make sure that they are recorded, that it's quite clear what the variation is, and do not forget what impact it has on the program. Very important, because the biggest claims in construction is delay and disruption. So you have to have that recorded in the register, and you have to make sure that the client doesn't provide instructions alongside or alone to the contractor. We have to have very clear distinction who makes the instructions. Most contracts would have an extension of time provision. That is not to protect the contractor, that is to protect the employer, the client. Why? In a contract, you will say, I want you to do the work from this time to this time. In between, you organize it yourself. That's fine. But if, according to the prevention principle, if there is any owner-caused delay, and it could be many of them, variation is one of them, you could have the situation whereby you could not rely on the end date anymore. So you need to have a mechanism to extend this. That's what they call the extension of time provision. So you as a client should make sure that the architect or the engineers grants the contractor an extension of time. If you don't, you are at risk that your contract is in what they call an at-large situation, which means they can finish the job whenever they want. That means they have to stay longer outside and you might have to pay. So all of this is a possibility. Provisional sums. Why would you have provisional sum? A provisional sum is you kind of tell the contractor, I don't have all the details for this, but I want to have a certain element extra in the works. For example, I want air conditioning. So you then give the contractor the information to put in a price for air conditioning. It's normally a rounded price, and you put it in, and that is added up to your contract price. The contract, the terms and conditions, will then provide that if you use this, we will take out the price that was provided and we're going to put in the price that it actually cost in your price. Now that could be more, so your price goes up. Again, it's normal. Why would you put that? Why would you work with provisional sums? Well, you want to be sure that the contractor knows that you have certain intentions. You want to know that the contractor, we're not going to use a very small air conditioning units. We're going to use this big, quite complex. So I want you to build that into your price. Why? So that later on you cannot tell me, the client, that you didn't know that there would be a very sophisticated air conditioning unit in it, and then I won't get an extension of time claim. The mechanism of which a final account is actually agreed is in the contract, and you need to be very clear what your contract says. Most people forget to look at that, but very important. Take the RIAI. The RIAI says if the architect is satisfied that the works are finished, and we are after practical completion, before the defect liability is over, the architect has to provide his final account draft to the client and to the contractor. And if none of them react within 10 days and say, we're going to arbitration because we don't agree with this, then that cert, when issued, becomes conclusive. Think about this. I had a case whereby an architect fell out with the QS, didn't like each other, personality clash, okay? The architect issued his final, a draft final certificate to the parties. The QS and the contractor kind of ignored him and said, look, ignore him, we'll continue with our negotiations, and they did. In the meantime, the 10 days passed, and the contractor issues the certificate, the final certificate. That's when I come in. The QS tells me that it's unfair. I think he might have quoted even natural law and all of that. And I had to tell him, the contract is clear. You had 10 days. This is conclusive. End of story. And we won the case in court. If you have the public works contract, there's other rules. This rule does not exist in the public works contract, but in the public works contract, it says if the works are finished, the contractor has, within 2 months after practical completion, to give a list of all the adjustments that are required to the contract. And if he doesn't, he's time barred and he can't claim afterwards. So if you don't know the rules by not looking at the contract, and you could be forgiven because you're not a lawyer. That's why you need your front-end lawyer. People will tell you, yes, but look, it's not that difficult because there are interim certificates. So as the work progresses, the interim certificates are there, and at the end, when all the costs have been well tracked, that's a big if, then we only have to look at the final interim certificate and the final certificate. Well, not so much. We have an English case, which is ICI versus MMT, ICI, Imperial Chemical Industry, part of AkzoNobel, versus MMT, and this is a major case. Okay, it has gone on for years and the animosity is huge, etc. One point I left out of there is interim certificates. The court accepts that the court can open it up and assess the interim certificates, perfectly entitled to do so. This is what happened in the case, where ICI says, ignore all those valuations, ignore all of them, and only look at my new valuation that I've set out here for you. there were MMT said, no, let's use the interim certificates. So the judge has said, you can reopen it, but I will place a very evidential weight on the interim certificates. Why? Because they are contemporaneous records. They were done by people in the know on the project at the time. And if you want to depart from that, then you better have very good reasons. Fact-finding, the records. Fact-finding is not to be underestimated. The RIAI came out with a very good idea, which is, why don't we train young architects to assist people and become what they call fact-finding commissioners. Fact-finding commissioners, or FFC, whereby at a very low price you can bring them in and they can agree what can be agreed. You might laugh and say, well, what can be agreed? Well, we might agree that my name is Bruno and your name is James. That's a beginning. We might agree that certain form of contract has been used, etc. And it's the skill of an architect who is effectively probably the best place to talk between the contractor and the client, so he can bring that together. Facts and law are a forced marriage. It's very difficult to bring them together. Forced marriage, okay, it's very difficult. And the Romans know that very well. If you look at Roman law, very, very clear. So for those of you that have done Latin, the expression is da mihi factum dabo tibi jus, which means give me the facts and I, judge, will give you the law. But Roman law continues. Idem est not esse, aut non probari, which means if it's not proven, it's not a fact. So we need the facts. The facts have to be proven. That's why we have to bring in the expert witness. And expert witnesses have always behaved very well, but more and more they started to behave badly. And the judge had to intervene. And in a very famous case, it's a shipping case called IKARIAN REEFER case. In the IKARIAN REEFER case, the judge, Cresswell, said, I've had enough of all those badly behaved expert witnesses. I want everybody to understand that an expert witness has a duty towards the court. Okay? So he has set out very helpful principles for any expert witness to be aware of. And in fact, lawyers should attend to it that this happens. The expert witness must be independent. The expert witness may not be influenced by the requirement of litigation, has a duty to the court, must only give evidence in his or her expertise, cannot omit materials of facts that are important, and also must not take the role of an advocate. It's not the role of a witness. In Ireland, in 2019, the Supreme Court endorsed this principle in the O'Leary versus Mercy University Hospital, Cork. It's a medical negligence case, but they accepted those principles of a shipping case. 2016, however, the rules of the Irish Superior Court have already changed, and we have Order 39, Rule 57, which is very clear that if you are an expert witness, you have a duty to the court. And this duty overrides the duty you have to the person that pays you. First, the court. And you have to say what your expertise is. Now, if you fail to do that, if you fail to comply with it, the judge can determine the admissibility, the relevance, the materiality, and the weight of your evidence. That goes very far. What is quite interesting is that in the UK, judges are absolutely outspoken about the badness of certain minority expert witnesses. Not so much in Ireland, but if you want a case where the criticism is well worth reading, the shopping list of what can go wrong is Judge David Wilcock in Great Eastern Hotel versus John Lang. But the case I mentioned to you before about ICI versus MMT is equally quite important. Ireland is not as strong on those. They will kind of talk more about the weight that it has. Big consequence is that if you are an expert witness in the UK, you can, by case law now, be professionally negligent and better have professional indemnity to cover you. Not required in Ireland. In Ireland, an expert witness doesn't have that obligation. Prudent lawyers, however, will ensure that their experts understand their duties and that the experts understand and that their testimony will be up to scratch in court. So facts are important. Understanding the scope of the works are important. Having it all written very well. Having your records. The last note, I noticed in Ireland was a small company. It's called On Record Limited. And what they do is they film what's going on a construction site. You might say, oh yeah, every contractor has it. Maybe, but the contractor uses it for health and safety purposes. And if there is a dispute with delay and disruption, you can be sure that the contractor wouldn't be too helpful to give you the data of that information. So you're better off to have that data yourself. On Record provided that. And their tagline, and I thought it was quite interesting, is if it happens on site, we have it on record. Now, ladies and gentlemen, if you use a front-end construction lawyer, if it happens on site, he or she should have it covered. And that's the only way you can get rid of or make sure that you do not have to encounter the litigator.